Hi, I'm Stacey from the Business Immigration team. I'm joined with Sarah and Gemma, who are part of our employment team.
How are you?
So today we're going to have a quick look at some of the changes that came into the immigration rules around the 4th of April and what really the knock-on effects might be from an employment perspective. So hopefully you who are listening to this are aware that the skilled worker default salary threshold increased to 38,700. And that was previously 26,200. So that's quite a big jump. But that really applies to new hires to your business. What we found from some of our clients is that there is less of an awareness of what happens where they're already sponsoring someone and you're extending their leave. So there is actually a different salary threshold that applies here. It is a lower amount of £29,000. And that's the transitional arrangement. So it allows a little bit of flexibility. What this really means in practice is that we need to consider that table in the immigration rules first before we make a decision as to whether or not we can continue sponsoring them. I'd like to give you a quick example. If someone was under the occupation code 3543 under the previous rules, so that would be a marketing associate professional, and say they were paid around £25,000 at that time. Now we need to have a look at what the transitional going rates are for this and the new salary threshold rather than the new threshold. For this particular code, it would now be £29,000. So as you can see, there's a clear difference between the default salary threshold and what this salary threshold is. If you find you're in a position where the salary that you're paying to a worker that you're looking to extend their sponsorship doesn't meet the requirements, this is when you need to take advice from an employment perspective. Gemma, Sarah, can I hand over to you?
Brilliant. Thank you, Stacey, for the summary of the changes to the immigration rules. As Stacey mentioned, there's potentially some impacts from an employment law perspective that we think is important to consider as a result of the changes. So ultimately, if as a result of the immigration rule changes, an employer is no longer able to support the sponsorship of a skilled worker visa for an individual employee due to the changes to the minimum salary threshold that Stacey took you through, when their current visa expires, there needs to be a consideration of what happens to the employment relationship and whether that unfortunately needs to be brought to an end. Now, in employment law, if an employee has over 2 years of continuous service with their employer, they will have the right to bring a claim for unfair dismissal. So in that situation, the employment relationship can generally only be brought to an end for one of 5 fair reasons, which are listed under the Employment Rights Act 1996. So Sarah, what are the 5 fair reasons?
Yeah, so as Gemma said, there are 5 fair reasons for dismissal, and they are within the Employment Rights Act 1996. So the first of those is due to capability of the employee. So that relates to their qualifications essentially for permitting the work of the kind that they were employed to do. The conduct of the employee, if an employee's role is redundant. The one that perhaps is most applicable here in terms of the immigration rules is if the employee cannot continue to work in the position that they have held without contravention either by them or the employer of a duty of restriction imposed or under an enactment, and the catch-all of some other substantial reason which can be relied upon to justify the dismissal. So in the situation where an employer can't continue to sponsor an employee as a skilled worker, that will fall within the 4th reason, which is commonly referred to in short as illegality. So if the employer can't justify the salary, if that's not market value, they can't continue to lawfully sponsor them, and therefore the employee won't continue to have the right to work in the UK. If they don't have the right to work in the UK, then that they're prohibited from working in the UK, and the employer is also prohibited from employing them to do that work. And therefore, this would provide a fair reason to bring the employment to an end. Sometimes we often see clauses in contracts as well, which relate to the employee making a warranty that they do have the right to work in the UK, and will inform their employer if they do not continue to have the right to work in the UK. This is important, an important clause to have in place. And if it is in place, then when the right to work doesn't continue, there could also be a breach of contract of their employment contract, and the employer could, in alternative, likely rely on the catch-all reason of some other substantial reason to bring that employment to an end.
Brilliant. Thank you, Sarah. So as Sarah mentioned, if the fair reason has been established, the next thing an employer would need to look at is following a fair process in bringing the employment relationship potentially to an end. So as part of this, the employer would need to discuss the background of the situation with the employee. Obviously, they're likely to be aware potentially of the changes to the immigration rules, but make sure they are aware and what that means for the ongoing employment relationship, and explain that ultimately there might, going forward, not be a lawful right to work in the UK if their current visa expires. As part of that process, what the employer should do is consider if there are any alternatives which they could look at to avoid having to bring the employment relationship to an end. So one example of that, as Sarah mentioned, potentially would be considering whether the employee's salary is currently at fair market value for the work that they undertake. If it isn't, and they could lawfully increase that, then they could look to increase the salary. And if that goes above the minimum threshold, then there would continue to be the right to work, and the visa as a skilled worker could continue and be renewed. However, it's important to flag that the salary can't be artificially increased just to meet the new thresholds. That wouldn't go down well with the Home Office, but there would also be some issues from an employment law perspective. So, for instance, the employer could face grievances from other employees within their business who didn't similarly get a pay rise, and they could also potentially risk claims of discrimination from other employees if they consider that they're being treated less favourably as a result of a protected characteristic under the Equality Act 2010. There's also potentially the more obvious claims of equal pay. So if an employee considers that they undertake the same or similar work to that of the employee who's had the pay rise, then they could bring a claim for equal pay as well. So employers must be careful in that situation when they're considering the alternatives, but that is an important step. Similarly, they need to make sure that the employee has the chance to suggest any viable alternatives that they foresee may be possible to ensure that the employment relationship could continue. So an example of that would be if the employee is able to retain their right to work in the UK through another avenue rather than sponsorship with the employer as a skilled worker. So that could potentially provide another solution. So Sarah, what would be the case if we've gone through that process and there isn't actually any solution to continue with the employment relationship?
Okay, so in the absence of a solution, if there are no other viable alternatives, the employee's employment would need to be brought to an end in line with the expiry of their visa. So if that's the case, the employee should receive payment for any accrued but unused holiday and notice if applicable. It might not be applicable. So if they're on a fixed term contract, for example, for the length of their visa, and that contract doesn't require notice for the termination of the employment at the end of the contract, then there may not be notice needed. But if there is, then notice needs to be provided for. That might be a payment in lieu of notice if you have a provision in the contract to do so. Or it may be that they need to work that notice. But if they need to work that notice, you need to be aware that they need to work that notice before the expiry of their visa. So you need to be having these conversations with sufficient time to build in any notice period that the employee might need to work. You'll also need to make any other payments due to the employee and confirm the arrangements around the end of their employment. So, for example, you need to remind them of their ongoing duties to the company. Often that's confidentiality or restrictive covenants, and arrange for the return of any company property at the end of their employment. There are some other options though. So do you want to talk through those, Gemma?
So as Sarah mentioned, there is a potential other avenue that employers could opt to go down. Now, this is entirely at the discretion of the employer. But what they can do is engage in what we call a protected conversation with the employee. And rather than proceed down the formal route, they can look to have a protected conversation and see if they can agree an amicable resolution to bring the employment relationship to an end, given the circumstances. Now, in the circumstances, obviously the changes to the immigration rules are outside the employer's and the employee's control, so they may feel that a protected conversation and agreeing an amicable resolution to the end of the employment relationship is the preferable route. However, as we mentioned, that's entirely up to the employer's discretion. But if they do choose to go down that route, it's important that they follow the correct process as well. to ensure it has that protection of without prejudice. So in either situation, what we suggest is that if you are in the position where the immigration rules have had an impact on your business, that you get in touch with both our employment team and our business immigration team so we can talk you through the changes and what impact that might have from an employment law perspective.
Thanks, Gemma. Thanks, Sarah. I think that was a really helpful summary from the employment law part. Like Gemma said, if you've got any questions, please do get in touch with us.